This hearing will come to order. The full committee hearing is on why isn't the Department of Homeland Security meeting the presidential standard for FOIA. I hope by the end of today we will find that it wasn't, but it is now. It is a policy of the committee to have our mission statement in our opening. So with that, the Oversight Committee, we exist to secure two fundamental principles. First, Americans have a right to know the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to Federal bureaucracy. This is the mission of the Oversight and Government Reform Committee. Today's hearing follows an 8-month investigation into what we believe are abuses of procedures at the Department of Homeland Security. This matter could have been resolved in July of 2010 when DHS first was confronted with allegations of political interference with FOIA process. And I might add that came from the Associated Press and others who looked into this. The Chief Privacy Officer, we believe, misled committee staff in 2010 briefing. If not for a whistleblower, the truth of the matter may never have come to light. That whistleblower was asked to clear her office, lost her job and title and responsibilities, was moved to a smaller office with narrower responsibility the day after she testified. That concerns us that the Department of Homeland Security is not taking their responsibility to the hardworking men and women in the FOIA Department to this day. The truth of this matter is that the Secretary's political staff did approve significant releases. They delayed they delayed responses, they withheld documents, they conducted weak searches, and by that I mean non-professionals searched their own documents using their own selected keywords and did not in fact avail themselves of the career professionals who were there long before them and know the system. Documents and witness testimonies show that the Chief Privacy Officer's statements from September 2010 are indefensible, yet several of them appear in her testimony at this hearing today. She continues to insist that the policy implemented in September 2009 was intended to merely make political staff aware of significant releases. The bottom line is responses could not go out the door until a political appointee said so. And the problem that the Department has not accepted accountability for. The disparity between the Department's FOIA compliance and the President's promise about transparency and accountability is stark. The committee is committed to getting to the bottom of the abuses of DHS and making sure that the politicalization of the transparency issue does not metastasize, that word I can do, throughout the Federal bureaucracy. The Chair is further concerned that there was a requirement we have discovered through whistleblower and documents that in fact one of the most important issues that came wasn't just the document related to FOIA, but in fact who was sending it, whether it was a political individual or the press. That reeks of Nixonian enemies list, and this committee will not tolerate it. With that, I recognize the ranking member for his opening statement.
I want to thank the Chairman for calling this hearing. And, Mr. Chairman, I've said it before and I'll say it again. My goal is to always be as constructive as possible. So let me start with what I think we do agree on. First, I think you and I agree with President Obama's decision on his first day in office to reverse 8 years of previous administration's FOIA policy, to adopt a presumption in favor of disclosure and to renew the Federal Government's commitment to FOIA. I think we would also agree that the process used by DHS to review certain FOIA responses in 2009, 2010 was not efficient, sometimes led to delays and caused confusion about roles and responsibilities that resulted in inter-office tension at DHS. Finally, I think we can agree that since then DHS has made significant improvements, but it must continue to take additional steps to fully address these concerns, and I am convinced that we can always do better. Despite some areas of agreement, however, we part ways when you make extreme accusations that are not supported by the documents, not supported by the interviews, and not supported by the investigation conducted by the DHS Inspector General's office. Over and over again, you have claimed that DHS officials are making FOIA decisions based on partisan political considerations. In July, you claimed that DHS, and I quote, ignored the intent of Congress and politicized the FOIA process, end of quote. In August, again, you claimed that political appointees at DHS, and I quote, inappropriately injecting partisan political considerations into the process, end of quote. You continue to make these accusations today, even though the committee has concluded interviews and conducted interviews and gathered documents that show the opposite to be true. The report you released yesterday accused DHS officials of, and I quote, illegal politicization, end of quote. It claimed that political considerations were an important factor in the process. And without requesting a single document from the previous administration, the report concluded that the FOIA process is now, quote, more politicized than when President Obama took office. These extreme accusations are unsubstantiated. In preparation for today's hearing, my staff examined 8 different allegations in detail. They reviewed the documents produced to the committee as well as the transcripts of interviews conducted by committee staff. We found no evidence that DHS withheld any information for partisan political purposes. We found no evidence that FOIA requesters received different treatment based on their political affiliation. And we found no evidence that DHS officials implemented the FOIA process to advance partisan political objectives. In every instance we examined, information was withheld only with the approval of either the FOIA office or the General Counsel's office. This is not just our assessment, and I repeat that. This is not just our assessment. This is also the conclusion of the DHS Inspector General, which issued a report yesterday refuting these specific allegations. This is what the IG investigator said. After reviewing information and interviewing DHS FOIA experts, we determined that the significant request review process did not prohibit the eventual release of information. It goes on to say, none of this information demonstrated that the Office of the Secretary prohibited the eventual release of information under FOIA. Information we obtained from FOIA, the FOIA staff, and our review of documents corroborates this assessment. It goes on to say, no FOIA officer said that the requesters were disadvantaged because of their political party or particular area of interest, end of quote. Mr. Chairman, our committee has a great opportunity to help Federal agencies as they strive to achieve President Obama's high standard. But we also have an obligation to conduct oversight that is responsible and indeed fair. In the long run, as I have said many times, we are just as concerned about government running well as you are. And it is just as important to us as it is to you, because we are Americans too, and we want our constituents to be served well. That's what this is all about. This is the American way, the all-American way. It's not about a Republican way. It's not about a Democratic way. It is about the American way. And so with that, Mr. Chairman, I want to thank you again for holding this hearing. And with that, I yield back.
I thank the gentleman. I thank him for using Chuck Schumer's extreme word the appropriate amount of times. Members may have 7 days in which to submit opening statements and include extraneous information into the record. Pursuant to committee rules, all members are to be sworn. Would you please rise to take the oath? Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record indicate both witnesses are in the affirmative. In order to allow time for discussion, this committee has a long-standing policy of asking you to your entire opening statements be placed in the record. We would ask you to stay as close as you can within 5 minutes. I don't cut people off mid-sentence, but if I think you get to the end of a paragraph, I will. We expect to have only one round of questioning unless there is a specific request for a second round. And our goal is to make this factual and succinct. So I will be pretty heavy-handed with people on this side. If someone runs to where you see a red light on during questioning and they still haven't gotten to the question, you may see a gavel and you won't have to answer. So it's fair warning to both sides that we want to keep you within your time. We also want members here to ask questions so that you have proper time to respond. Additionally, we are not prohibited from having votes. If we have votes, we will wait until about 5 to 10 minutes after the vote has been called, because the first one is 15. We will recess, and as soon as there is a two-person working group back here, we will reconvene. Even if I am not back here, whoever the senior Republican is will commence so that we can be cognizant of your time and schedules. Hang on one second. Didn't want to make any mistakes on the name, even though they're in front of me. The Chair now recognizes our first panel. Ms. Mary Ellen Callahan is the Chief Privacy Officer, Department of Homeland Security, and Mr. Ivan Fong is the General Counsel to the Department of Homeland Security. We're pleased to have both of you here today, and with that, ladies first.
Thank you, sir. Good morning, Chairman Issa, Ranking Member Cummings, and distinguished members of the committee. I am Mary Ellen Callahan, the Chief FOIA Officer and Chief Privacy Officer at the Department of Homeland Security. My office administers policies, procedures, programs to ensure that the Department complies with the Freedom of Information Act and the Privacy Act. I appreciate the opportunity to appear before you today to discuss the Department's Freedom of Information Act processing and policy, both past and present. 2 years ago, the Department faced a backlog of more than 74,000 FOIA requests. We began to work immediately to address the issue and have had success. Under this administration, we have reduced the backlog by 84%, or more than 63,000 FOIA requests. In fiscal year 2010 alone, DHS reduced its backlog by 40%, eclipsing both the government-wide Open Government Directive's instruction to reduce the FOIA backlog by 10% each year, as well as DHS's own Open Government Plan's goal of a 15% reduction for the fiscal year. In FY 2010, 650, less than 0.5% of the more than 138,000 FOIA requests processed were deemed significant by career FOIA officers pursuant to the standards that were established at the Department in 2006. The significant requests include those related to ongoing litigation, related to sensitive topics, requests made by the media, and requests related to presidential or agency priorities. In these relatively few cases, senior Department management was provided an opportunity to become aware of the contents of a release prior to its issuance to the public, to enable them to respond to inquiries from members of Congress, to enable them to respond to inquiries from their staffs, media, and the public, and to engage the public on the merits of the underlying policy issues. The significant FOIA review process began after several significant FOIAs were released at the beginning of the new administration without notice to senior management. These significant FOIA responses related to ongoing litigation, records from the previous administration, and records from other departments. The bottom line is that basic lack of awareness of significant FOIA responses hindered the Department's abilities to manage and oversee the Department. The transition of where we were then and where we are now was not seamless. There were management challenges in implementing the awareness process initially. However, we recognized these problems at the time and have taken significant action to address them. I believe that transitioning to the SharePoint system last year represents a significant step forward, and I believe it is now a system that works effectively and efficiently for FOIA professionals in my office and for senior management across the Department. At the same time we were implementing this awareness process, the average number of days it takes the Department to process a FOIA request has decreased significantly from 240 days to 95 days, a record of which the Department is rightfully proud. There have been allegations that political appointees in the Department's front office redacted FOIAs and restricted their release. Let me be clear. To my knowledge, no one other than a FOIA professional or an attorney in the Office of the General Counsel made a substantive change to a proposed FOIA release. Further, to my knowledge, no information deemed releasable by the FOIA Office or the Office of General Counsel has at any point been withheld, and responsive documents have neither been abridged nor edited. I would also point the committee to the Inspector General's independent analysis that makes many critical findings, including the significant request review process did not prohibit the eventual release of information. No FOIA requesters were disadvantaged because of their political party or particular area of interest. The Office of the Secretary is responsible for overseeing DHS operations and thus is well within its rights to oversee the FOIA process, and DHS has made important progress ensuring openness, including through proactive disclosure. We concur with all 6 of the IG recommendations. I am heartened to see that the Inspector General sees the progress we have made. We are committed to doing more, and we look forward to working with the committee on these important issues. I'd be happy to take questions. Thank you.
Thank you. Mr. Fong.
Good morning, Mr. Chairman, Ranking Member Cummings, and distinguished members of this committee. My name is Ivan Fong. I am the General Counsel of the Department of Homeland Security. I appreciate this opportunity to appear before you today to discuss the Department of Homeland Security's Freedom of Information Act policies. As General Counsel, I lead and oversee a law department of more than 1,800 lawyers in our headquarters and our component legal offices. In my leadership capacity, I emphasize the important role DHS lawyers play both in advising on and in ensuring compliance with the law, and in setting high standards for professional and personal integrity across the Department. In the course of performing their duties, headquarters attorneys as well as lawyers in our component legal offices may be called upon to interpret the FOIA statute and to apply its provisions to records collected and processed by the Office of Privacy for possible disclosure in response to FOIA requests. As you know, FOIA establishes a mechanism that makes records held by agencies and departments of the executive branch accessible to members of the public, except to the extent the records or portions thereof are protected from disclosure by one of 9 statutory exemptions or by one of 3 special law enforcement record exclusions. The 9 exemptions included in FOIA reflect Congress's recognition that the goal of an informed citizenry, vital to the functioning of a democratic society, must sometimes be balanced against other important societal goals, such as protecting the confidentiality of sensitive personal, commercial, and government information. This administration has taken significant steps to increase openness in government. In January 2009, for example, President Obama issued 2 important memoranda to the heads of executive departments and agencies concerning government transparency. In his Transparency and Open Government Memorandum, he committed this administration to an, quote, unprecedented level of openness in government, unquote. And in his Freedom of Information Act memorandum, he stressed the importance of FOIA, stating that it is, quote, the most prominent expression of a profound national commitment to ensuring an open government, unquote. To reinforce this commitment to transparency, Attorney General Holder, in March of 2009, issued a guidance memorandum that, among other things, reiterated the President's call for proactive disclosure in anticipation of public interest, required agencies to consider making partial disclosures whenever full disclosure of a record is not possible, and urged agencies to create and maintain effective systems for responding to requests. Against this backdrop, the Department's lawyers provide day-to-day legal advice to the Department's Chief FOIA Officer, her staff, and others in headquarters and other components who are responsible for responding to FOIA requests. In doing so, the lawyers who practice in this area provide legal advice on specific requests and potentially responsive records, and they do so based on their best understanding of the facts and their best legal analysis and interpretation of the FOIA statute, the relevant case law, and applicable guidance. With respect to the involvement of the Office of the Secretary and other senior Department leaders in being informed of significant events affecting the Department, including the release of significant departmental information, the Secretary and her staff have, in my view, clear statutory authority to ask questions of, review, and manage the operations of all parts of the Department, including the Privacy Office and its elements that handle the FOIA process. Similarly, the Attorney General's 2009 guidance states in relevant part that responsibility for effective FOIA administration belongs to all of us. It is not merely a task assigned to an agency's FOIA staff. It is therefore my view that it is not only legally permissible, but sound managerial practice for the Office of the Secretary to be informed of and, in coordination with the Chief FOIA Officer, to play a role in overseeing the Department's FOIA processes. As my colleague, Ms. Callahan, has just described, the significant FOIA review process has evolved over time to become more streamlined and more efficient. Despite some challenges in the early implementation of the review, and those problems have been acknowledged and remedied, the Office of the General Counsel will continue to engage with the Department's Chief FOIA Officer and staff across the Department to help ensure that we continue to disclose responsive records properly and promptly and in a spirit of cooperation that adheres to the letter and the spirit of the President's direction. Thank you very much, Mr. Chairman.
Thank you. I'll now recognize myself for 5 minutes. Ms. Callahan, is AP on your enemies list? I'll take that as a no unless you want to answer. I mean, there's been this talk about, in your opening statement, about, political. Yes, there were members of Congress and others who wanted it who have R's and D's after their name. But it appears as though your office wanted to know if the Associated Press wanted something. You wanted days to pre-release or to spin or to decide to take information that was sensitive or embarrassing and get it out in some format you wanted days before the Associated Press would have what they waited weeks or months for. So let me just understand this. The words you used, because I want to make sure that the words are very careful, because what you said to the committee turned out not to be completely accurate some time ago. You used the word eventual repeatedly. Eventual means that a right delayed is not a right denied. You stand by that position that 3 days, 6 days, 90 days, they're all okay as long as eventually you comply with FOIA? Yes or no, please. Is eventual good enough? Is a delay of 3 days, 30 days, or 90 days okay and still compliant with FOIA, in your opinion?
The initial FOIA review process had management.
Answer the question, please.
We have made great strides to.
Is a 3-day, 30-day, or 90-day all acceptable as FOIA compliant? Because you used the word eventual, but in fact there were clear delays produced by this policy of pre-alerting as to who wanted what so that political appointees could do what they wanted before it got out in some other way. So is 3 days, 30 days, or 90 days an acceptable delay and still compliant with FOIA? Yes or no?
I have very high standards, and
Mr.
that did not
Fong,
meet my standards.
you're not answering the question.
I did, sir. That did not meet my standards.
Okay. So you didn't meet the standards. You were causing delay, and eventual should not be a wiggle word here in your statement. The fact is there were delays. The IG saying it did not stop eventual delay didn't change the fact you were delaying. It did meet your standards. And if the IG were doing their job, you would clearly have the need to stop eventual and make it prompt. Mr. Fong, you were aware that there were delays produced as a result of political appointees receiving this information. Did you do anything about it? Did you consider it a problem that 3 days, 30 days, or 90 days of additional delay occurred because political appointees were evaluating the sensitivity of a piece of maybe embarrassing information or politically sensitive information becoming public?
I believe that it is important for FOIA responses to be promptly disclosed. I believe also, though, that the Secretary's office has a legitimate interest.
So you believe that a delay in order to evaluate the political ramifications and potentially release something someone's waited for 90 or 180 days for, release it before you even give it to them, is okay under FOIA? Because that's what was possible as a result of this policy, wasn't it?
With all respect, Mr. Chairman, that's not what I said. I said that it is important for releasable records to be released. What I believe, though, also is that the Secretary's office has an interest in knowing what is
Mr. Fong, I asked about the interference. I did not ask about the interest. Nobody on this dais, I believe today, will assert that if, as a FOIA request was going out, simultaneously, even the evening before the morning, it was sent to the offices so they would be aware and be able to develop appropriate responses if the very next day it appeared on the front page of the New York Times. Bottom line, though, is your offices had them days or weeks or months beforehand, and in some cases clearly could have spun the story before the facts were given out. Let me move on to one thing. Put up slide number 1, and there will be more slides today, but this one is, it's very hard to read that. Do you have a copy? Okay, would you please get the witnesses a copy? And essentially, you have an exemption for pre-decisional communication. On the left, you'll see the redacted version. On the right, you'll see, and this was the type of information the AP was looking for that they felt that this policy confounded. It says, this is for you, Mary Ellen Callahan, were you concerned that the forwarding of every request on a weekly report to the Secretary's political staff would burden the staff? In other words, that's one of the things redacted. Or more specifically, it says, not sure what the confusion is, but please know this request is coming directly from the front office. NOAA is fully briefed. Can you please have your staff forward the actual FOIA request that are included in our weekly reports each week so we can refer to them as needed? Now, that was redacted. So basically, you've made a decision. The decision is to forward it. A newspaper agency wants information, and what I read here is we're redacting it about not a pre-decisional process, but a decision that's been made. And this was exactly what they wanted to understand. The AP wanted to know and had a right to know, a constitutional obligation under freedom of the press. They wanted to know if you were doing exactly what you were doing, and that information was redacted in this. Now, you have a copy of it. Please respond. My time has expired, so we'll be brief.
Actually, Mr. Chairman, with regard to the AP request about FOIA processing, my office was recused, as is the normal practice, if my office is the direct subject of the FOIA request. And so my office did not make that B-5 determination. The Office of the General Counsel did. Okay.
So, Mr. Fong, you redacted actual substantive information that clearly was exactly what the AP was looking for. You redacted it when they tried to get their information. It was not pre-decisional. It was not executive privilege, but it clearly was what they had a right to know and we're finding out about here today. Would you explain why?
Well, Mr. Chairman, I was not personally involved in making this decision. My staff, though, does have expertise in this area. I cannot speak to this particular redaction or other redactions that were or were not made. I can say, though, that there is an administrative appeals process that exists precisely to correct such issues and to correct any mistakes. My understanding is that these records are going through such an appeal, and I believe it would be premature, therefore, for me to opine.
Okay. Well, my time has expired. We're going to go to the ranking member, but what I will do is I'm going to have copies of all of this delivered to you so you can look through them and know them in advance, because we have a number of these types of records, and I think the ranking member would agree with me that, quite frankly, it's very hard to appeal a redaction because you don't know what you don't know. I yield to the ranking member.
Thank you very much, Mr. Chairman. Let me, one of the things that I have seen in this committee before, and it's something that I'm very concerned about, is when people come before us and you're not allowed to try to answer the question that you've been asked. So I'm going to go to you, Ms. Callahan, and because I realize that this is not an easy process, that you're coming before a committee and you're probably a little nervous, and people are watching this, and there's life after this moment, and you have a reputation. And I want to give you a chance to answer the question. You tried to, but you weren't permitted to. You stated that delays do not meet your high standards. And during the delays that the Chairman Issa discussed, were officials weighing partisan political concerns, to your knowledge?
To my knowledge, they were not, sir. And that was confirmed by the Inspector General's report.
And what were they doing?
Sir,
to your knowledge?
To my knowledge, the front office was wanting to have awareness of significant FOIA activities in order to engage the public on the underlying merits of the debate. They were not delaying it. They may have not had the opportunity to review it in a timely fashion, and that did not meet my standards, which is why we shifted to the SharePoint system described in more detail in my written testimony.
Now, were there instances where the General Counsel, was the General Counsel reviewing documents for legal sufficiency so that they could meet the standards?
There were at times, as I understand, some documents that had been identified as being insufficiently or inappropriately processed. And for that, they went to the Office of the General Counsel for a further review, as is a typical process in the Department of Homeland Security.
And let me ask you this. Were you taking your time in order to, quote, spin stories prior to release of documents?
No, sir. To my knowledge, the Department was not engaging in spin. They wanted just awareness of the underlying issues in the FOIA releases that they did not modify. They just wanted to know what was in the documents.
And I want to thank you for saying, and I know you mean it, that you have high standards. And we understand that you're one person and you've got people that work with you. Is that correct?
That is correct, sir.
Ms. Fong and Mr. Callahan, the Chairman has repeatedly stated that DHS officials make FOIA decisions based on partisan political factors. Last summer, he said that political appointees were inappropriately injecting partisan political considerations into the process. And in his report yesterday, he said political considerations were an important factor in your FOIA decisions. These are serious, very serious allegations. But based on our review of the documents and interviews, we could not identify any instances where this actually happened. So let me ask you directly, are either of you aware of any case in which DHS withheld information from FOIA requesters based on partisan political considerations?
I'll answer first. No, sir, I am aware of no such circumstance.
So,
And I am not aware of either.
the Inspector General, who will testify on the next panel, also refuted this allegation. And in his report, and this is the Inspector General, he says, after reviewing information and interviews of DHS FOIA experts, we determined that the significant request review process did not prohibit the eventual release of information. He also said this: no FOIA officer said that requesters were disadvantaged because of their political party or area of interest. Are you familiar with the IG's finding, and do you agree with them?
Sir, I am familiar with the IG's findings, and I do agree with them, and I appreciate their inspection in this matter.
Well, let me turn to what I think was the real problem. Our review found that your two officers were not working together, as efficiently and effectively as they could. In fact, we found that there was real tension between the FOIA's office and the General Counsel's office. And let me give you an example. On March 3rd, our staff interviewed Catherine
Papoy, sir.
Papoy, who works in Ms. Callahan's office. She told our staff that she had serious issues with an attorney who handles FOIA requests in your office, Mr. Fong, and when Ms. Papoy was asked to describe the problem, she said this, and I'm quote, "I do not consider him to have expertise in FOIA. There have been several times I have had to educate him on some very basic concepts." Mr. Fong, how do you respond to her concern that the attorney in your office was not qualified to work on FOIA requests?
I disagree with the view, Congressman, that this attorney in question was not qualified to respond to her requests. As you know, FOIA is a very technical and complex area. It is true that he does not practice in this area full-time, but he oversees a group of lawyers who do, and he has, I believe, very good judgment and applied his best understanding of the statute and exercised good faith and reasonable judgments to the questions that he was presented with.
So let me be clear. This has nothing to do with political issues. These are two career employees that seem to have difficulty working together. I think we see that all the time, even here on the Hill. And Ms. Callahan, how about you? How can we expect the FOIA process to work when career officials in your office and Mr. Fong's office can't work together?
Sir, we are working to address what are reasonable disagreements among others, and I think it's important to make sure that we put personality aside and try to work to solve this problem. So we recognize it to be a concern, and we are working diligently on it.
And finally, let me back this up. As the leaders of your two offices, is it your job to get your employees to rise above these current tensions and rebuild the trust level? And what is your plan to do that, and how do you plan to resolve substantive disputes between your offices in the future?
I strive to be a good manager and make sure that, indeed, these types of issues are not impacting the effectiveness of our offices. And I will work diligently to attempt to address that through individual consultations as well as perhaps collective ways to resolve personality issues, not dealing with substantive issues.
Mr. Fong.
Thank you, Mr. Chairman. Those who've worked with me know that I take my leadership and management responsibilities very seriously. I have spent a lot of time in my almost 2 years at the Department ensuring that our lawyers work well with their clients and others around them. I have taken specific actions to remedy issues that have arisen. And as you said earlier, this is not unusual for career professionals who care deeply about what they do, who are very dedicated, hardworking professionals, to disagree at times. And as you said, I believe they should try to rise above their disagreements.
Thank you very much, Mr. Chairman.
Thank you. For the record, we have been informed that the AP's 9-month-old application under the administrative objection has not yet been heard. With that, we recognize the gentleman from Utah, Mr. Chaffetz.
Thank you, Mr. Chairman. Ms. Callahan, I'm going to refer in part to the Associated Press report of July 21st, 2010. I'd like to read some statements from that and get your reaction to them. Tell me if you believe them to be true or false. Quote, "If a member of Congress sought such documents, employees were told to specify Democrat or Republican." End quote.
Sir, that is how congressmen are referred to ordinarily. In fact, under the significant—
But this was a new policy, correct?
If I could, sir, it actually is not a new policy. It was policies established in 2006. And it is, in fact, during the significant, the weekly report in which we report these elements.
To the White House, correct?
Actually, no, to the Department. And then the Department summarizes, may or may not report specific elements to the White House. We haven't had—
This says, and sorry, but I want to clarify this.
Yes, sir.
The report that was putting together, second sentence of your July 7, 2009 issuance from you says the Privacy Office FOIA leadership integrates the information into its weekly report to the White House liaison, end quote. So it was for the White House, correct?
And by integrating it, I don't know what goes on with the integration process.
But it was for the White House.
They may or may not include it.
It was for the White House, correct?
Sir, that's the front office process. I did want to point out that for this weekly significant reporting process, in the 2 years that I've been here, I believe a member of Congress has been listed on it once.
Let me read this, starting in the first paragraph. Quote, for at least a year, the Homeland Security Department detoured requests for Federal records to senior political advisors for highly unusual scrutiny.
I disagree with that assessment, sir. As demonstrated more thoroughly in my written testimony, it was a process to provide awareness to the senior leadership.
Let me keep going. Probing for information about the requesters and delaying disclosures deemed too politically sensitive, according to nearly 1,000 pages of internal emails obtained by the Associated Press.
As I've discussed with the ranking member and as indicated in the Inspector General's report, there were indeed management challenges with the initial way that we tried to do this awareness process. However, political affiliation, parties of interest did not play a factor. It was logistical issues rather than management challenges, and that's demonstrated throughout this inspection.
It certainly seems to be inconsistent with your directive of July 7, 2009. Let me read another sentence. The Department abandoned the practice after the Associated Press investigated. Is that true?
It is not true. Absolutely not. The awareness campaign, the awareness
Let me keep
process
going. Thank you.
Continues today.
You've answered the question. I've got a short amount of time.
Sorry, sir.
Let me keep going. Career employees were ordered to provide Secretary Janet Napolitano's political staff with information about the people who asked for records, such as where they lived, whether they were private citizens or reporters, and about organizations where they worked, end quote. Is that true or false?
Again, this has been a process since 2006 to provide awareness into significant issues that may become in the public domain.
Let me read another paragraph. Two exceptions required White House review. Request to see documents about spending under the $862 billion stimulus law and the calendars for cabinet members. Those required White House review. Is that correct?
The calendars, anything that has White House equities would require White House review. That's a typical
What is a
process.
White House equity? What does that mean?
In the circumstances with the Secretary's calendar, to the extent that she was in the White House or that was disclosing some sort of element, this is a typical process of referring FOIA requests to different departments. It may be their underlying records. And so that's a standard process throughout the Federal
government. The other
government.
part of that is under the $862 billion stimulus. Is that correct? Is that part of the White House equity? It says two exceptions required White House review. Request to see documents about spending under the $862 billion stimulus law. Is that correct?
That is correct.
Why? Why does that require special White House review?
Sir, I'm the Chief FOIA Officer. I'm not a policy person in this area.
So is that a directive that you got from the White House?
I believe I was instructed by the Office of the Secretary to do that, and we processed it
So the Secretary, who directed you to do that? Is that a document that you can provide for us?
I believe it's in the production. I believe it was the Deputy Chief of Staff.
Okay, Deputy, if it's not in the record, will you provide that for us?
Certainly. I believe it's in the record, and it was the Deputy Chief of Staff who instructed us to do so, and we did so.
All right, one last question. Calendars, let me see. My time's expired.
Would the gentleman yield?
Yes.
Who was that one member of Congress that was sent to the White House?
It wasn't sent to the White House, sir. It was listed on the weekly report.
Who was it?
It was, I believe, Senator Grassley. When he was asking for a request, we ended up modifying it and not answering it via FOIA, but through a different process. Members of Congress actually don't file FOIA requests very often, so the issue on the members of Congress is a relatively moot point.
Except, of course, that the White House has told us to file FOIA when we're in the minority and not responded otherwise. We now recognize the former Chairman of the full committee, Mr. Towns, for 5 minutes.
Thank you very much, Mr. Chairman. Let me begin by, first of all, Ms. Callahan, thank you very much for your service. We've had an opportunity to follow your record, and you've done some great things down through the years, and we want to thank you for that. You've been asked many questions about acceptance of delays in responding to FOIA. Can you please explain to this committee what circumstances or what situations that might delay you in responding to FOIA? Yes.
Yes, sir. As you know, we take our FOIA responsibilities seriously. At the same time, there are several processes and steps that I detail in my written testimony that describe the process that every FOIA of the 130,000 FOIAs that the Department received last year, each FOIA must go through these steps to make sure that indeed we've identified the Federal records, we've identified the parties who may have the information, that we've applied the appropriate exemptions, that we've looked at legal issues therein, that the process has been reviewed to make sure that indeed there isn't any information that is inappropriately disclosed or inappropriately redacted. And so despite having high standards, the average processing time for FOIAs in the Department is 95 days. That is, right now, several days more efficient than the Department of Justice at 113 days, but it is a standard that we are trying to achieve and surpass. So delays are not appropriate for any FOIA, and we are trying to mitigate that problem.
Are any of these delays caused by political involvement?
Sir, as I had described in my initial testimony and my written testimony, there were some processes that were involving the awareness review for the Department, but did not involve political activities or instigations, as the Inspector General has indicated. The initial way that we started to give the front office of the Secretary awareness into some of the significant FOIAs that may make media attention was not up to my standards, and therefore we have modified that process, and I believe now we have a best practice in terms of providing awareness not only to the front office but also to the other FOIA officers if indeed that there are FOIA requests that may impact their equities.
Ms. Callahan, can you explain the 2006 directive in which FOIA requests are referred to the Secretary's office? Could you explain that? And I'm not going to tell you, give it to me in a yes or no.
Sir, I can't explain it because I wasn't here in 2006, but I understand that it is the ordinary process of all administrations to have awareness into significant activities in each of the components. My privacy office provides actually 2 weekly reports, one on the activities of the entire office, and then separately on FOIAs that have been provided that may meet these standards for awareness for the front office. But I understand it is a typical practice not only across the administrations but also across the Federal Government.
Right. Thank you. Mr. Fong, what do you feel can be done to eliminate some of the delays?
Well, I think a lot of what can be done has been done in terms of the significant review process. Having it on the SharePoint system for one day gives time for awareness, but does not add to delay the process of releasing the documents. I think in general, if we were more coordinated as a department, I think we spend a lot of time as a relatively new department trying to figure out who may be relevant component program individuals, what documents need to get to whom for the FOIA professionals to review. Our lawyers are very busy, they're hardworking, but their plates are full. It takes time to do an analysis, to gather facts, to make judgments. I would also say that while I agree that it's important to be prompt, there has been much made of the 20 business day timeline, which in my view is a misnomer if one thinks of it as a violation. It merely provides that the agency must make a determination within 20 business days, after which a requester may appeal or may seek judicial redress if such a determination is not made. There are provisions that permit an agency to request an extension, and as Ms. Callahan indicated, many agencies take on average longer than 20 business days to respond to a FOIA request. So I just want to make clear that while we have an interest in releasing promptly, this is a process that courts and others have recognized as the Federal Government has become more and more complex, inherently takes time.
But thank you very much, and thank you both for your service. I yield back.
I thank the former Chairman, and now I recognize Mr. Meehan for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ms. Callahan and Mr. Fong, for your appearance here today before our committee. Ms. Callahan, thank you for your service. You do not have an easy job. It's a complex job, particularly with the great scope of information that is associated not just with the free flow, but also at times information that may relate to investigations or other kinds of. So it's not an easy job. But I do note that at least the AP has reported in December 2009 that you found that there was a level of scrutiny. I think we have had the base established here through prior testimony. You understand what I'm talking about in the form of the oversight of political appointees. You say that this level of attention is crazy. I really want someone to FOIA this whole damn process. What did you mean?
Sir, if I could, that, of course, was a communication with my staff, and I was attempting to support them in this process. As I've indicated earlier, the initial process for the awareness review was not efficient, and it had its management challenges. At the time, therefore, that's why we have moved to the SharePoint system that Mr. Fong has referenced and I detail in my testimony. And I think that that's an important element. We were not even technologically able to do that in December of 2009. In fact, SharePoint didn't come on to my office until March of 2010. So at the time, I was discussing not about the awareness review, because I continue to believe that the Secretary does have important equities in having awareness into this, but that the level of detail and paying attention to it perhaps was not where I would have put my emphasis. And
is it your testimony then that was purely process? And
yes.
And so it was just a question of process.
Not a question about not questioning the review itself, but the level of detail, thus missing the 3-day window.
But we have established that there is a level of review now that goes on in the form of responsibilities for political appointees to have to affirmatively indicate as to whether or not information is to be released.
Sir, let me be clear. That process has been modified, and we no longer have that process at all. That was the initial process, and as I have indicated, that had significant management challenges. That did not meet my standards, and that is why the process is modified.
What's the difference? Well, so this doesn't happen at all now? There's no affirmative review by
Absolutely
anybody?
Not. There is an FYI review. So what had happened before is previously we had no way of sharing the FOIAs, not only between the front office and my office, but also between the components, except by email.
Well, then are you making the calculations with respect to sensitive information or other kinds of things? Let's suppose there's no politics being played here, but there is a security interest. Are you responding to this based exclusively on the issue of what is in that document from a FOIA perspective, or is there anybody looking at redaction or other kinds of issues?
So, sir, with regard to the current system, if I could just describe the current system, it may help explain it. The current system, we now have an intranet-based system where we can upload it, and the FOIA officers can upload it directly. And then not only can the people with equities review it, but also the other FOIA officers can review it if they have equities in it as well. So it's accessible in a centralized base. And in that way, we send out a notification and say that the request has been made, let's say.
So it's a notification process.
It is a notification.
There's no more thumbs up or affirmative by virtue of any other kind of person above you?
That is correct, sir, and that was changed in July of 2010. And we believe that this process, it's just a notification process. People can look at the underlying documents, and that has happened a couple of times, going to your question, where people have caught either pre-decisional information that may have been sent out, inaccurate or incorrect or insufficient redactions. It's only happened a handful of times since July of 2010. That's a much more efficient and better process.
So it would be your testimony that there's no longer any delay associated, as there had been in the past, where something would have been prepared for release by you, but it would have taken an additional period of time to flow up the chain before you got the affirmative approval by the political appointee?
The new SharePoint system has the documents uploaded one day, and then they're sent out the next day. So there is arguably a one-day delay, but as Mr. Fong pointed out, that is to make sure that we don't disclose law enforcement sensitive or other pre-decisional information inappropriately.
Mr. Fong, what level, and I'm out of time, but what level of training or engagement do you have with those political appointees about their responsibilities and their obligations under the Freedom of Information Act who participate with you in the review of these documents?
I just want to be clear what your question is when you refer to the political appointees. Are you referring to the
those
front
who
office?
in the past must have had to affirmatively indicate. This is a complex area, and you appreciate that. If they were doing the affirmative indication, and now presumably that's no longer the case. I'm happy to hear that. I'm concerned with moving forward, notwithstanding if they're still participating with you in that. To what extent do those individuals, do they have any say? May they be able to reach back to you and tell you, oh, wait a second, do not release that yet?
Of course. That is part of the process then and now. That the attorneys in our office who have experience and expertise in this area stand ready to be consulted at any time, whether it's the FOIA professionals or the political appointees or the program managers who will have a much better sense of the impact of a disclosure as is required to be assessed under the Attorney General's guidance memo. All of that information is relevant to making a legal determination, and our lawyers are involved in making those determinations.
The gentleman's time has expired. Mr. Tierney of Massachusetts is recognized for 5 minutes.
Thank you, Mr. Chairman. You know, I'm a little bit surprised we have a hearing here where allegations of politicization are being made in one direction, yet I look behind the Chairman's desk and I see nothing but pure politics and nonsense up there, and I would hope that in the seriousness, or if we're to be taken seriously as a committee, the majority would begin to act that way and take that material down and approach this with the degree of seriousness to which it probably deserves. That said, Ms. Callahan, I want to thank you and Mr. Fong for your testimony. I do want to note Mr. Chaffetz is gone, but he was referring to an AP story, and I know that eventually the AP story said they were unable to substantiate the most serious allegations made in the AP story or subsequent public comments. So just put that in context. But I was concerned, what I thought at one point in this testimony was that events involving the ARA, Recovery Act, there seemed to be some indication that it had to be sent to the White House. But I asked the staff to go back and get the interview with the Associate Director of Privacy, Vanya Lockett, who basically told us that at one point she thought she was advised that all requests needed to be sent to the White House, but since then she was advised directly from the White House that that was not the case. Does that comport with your understanding, Ms. Callahan?
Thank you for that clarification, and that does refresh my recollection that indeed that is the case. Thank you.
Thank you. Now, I note also that the Department of Homeland Security, in just last year, 2010 alone, received some 130,000 Freedom of Information Act requests. Is that accurate?
That is correct, sir.
And about 600 of those were considered significant enough to require an additional review. Is that right?
That required to be even put onto the weekly report for notification purposes, sir.
Okay. The Inspector General did indicate that he thought about approximately 85% of those responses had already surpassed the statutorily mandated 20-day processing deadline before they were submitted to the Office of the Secretary. And he also said about the delays that the ones that were under the review process were short, 1 to 4 days in delay. These relatively brief delays still caused temporary withholding of certain documents that a component was prepared to release. Do you agree with that assessment?
I do agree with that assessment, but that, of course, was under the original awareness process that I discussed with Representative Meehan, and therefore we have modified that process to make it a notification-only system. So I believe we have mitigated the Inspector General's concerns in that way.
Now, also note that when this administration took office a couple of years ago, they already had a backlog in the Department of more than 74,000 FOIA requests. Is that accurate?
That is correct. The highest FOIA backlog we had was 98,000 in fiscal year 2006, the highest in the Federal Government's history, actually, sir. Okay. But we've gotten it down to 11,000 FOIA request backlog, an amazing effort by serious and professional career FOIA professionals throughout the Department.
It strikes me that, a time of fiscal austerity here, that you have to hire some 40 more full-time positions in the Freedom of Information Act Division to actually deal with this enormous number of requests for information.
Well, sir, I believe that indicates the Department's commitment to FOIA to increase the number of hires during the administration by over 50 positions.
Yeah, I think it deals with seriously. We've got a lot of challenges to make here in Congress and a lot of choices to make with respect to the budget, and there seems to be somewhat of a commitment there to take 40 full-time positions allocated towards freedom of information with all the other competing interests that we have on that. Now, the thing that strikes me is that H.R. 1, a bill put forward by the majority this year, would actually make across-the-board cuts to the Office of the Secretary, significant cuts on that, about 9%. The President was going to raise it 9%. H.R. 1 is going to take that away and make more cuts. What's that going to do to your attempts to get at the transparency issue here and be more responsive to the FOIA request?
Sir, I believe it could significantly hinder it. I've been able to double the size of my own FOIA staff since I've been there, and the Department has shown commitment around FOIA across the board, as you notified, as you indicated. But I'm concerned that these cuts will significantly impact our FOIA processing, and the FOIA officers throughout the Department discussed that with me yesterday.
Mr. Fong, do you agree with that?
I can't speak directly to the impact it would have, but I concur with Ms. Callahan's judgment that any time one has to reduce resources, there is likely to be an impact. We are trying to make our processes at the Department as efficient as possible, but there is an inevitability about such a drastic reduction, as you've indicated.
Thank you. I thank you both for your testimony. I yield back.
Thank you.
I thank the gentleman for yielding back, and at this point, Mr. Lankford is recognized for 5 minutes.
Thank you very much, and thank you both for being here. The SharePoint system, as you've been discussing, it does sound like a very efficient system, and that seems like that is working well, and you're comfortable with the process on that. I understand how that's going to be a lot better than emailing documents back and forth, uploading them, being able to pick them up, and get a chance to gather them and be able to review them there. Does that increased efficiency help in the budget area as well? Does it help with the number of staff members that are required to handle that? You've seen the increase in efficiency in the communication. Does it increase efficiency anywhere else?
That's an interesting question. I hadn't thought about it before, but I think that because it's a centralized system and because the labor is actually dispersed, because the component FOIA officer will upload the information and then my office will just do the notification to across the Department, that it probably does make it more efficient for labor as well as for awareness.
Great. You mentioned before there was a one-day, basically the day before front office gets it, and they can have this uploaded before it actually gets sent out to the requester itself. Have you had at any moment someone that has, once the notification has been made, there's been a contact back and saying, hey, hang on to that one for a minute. We need to be able to either check it for other areas or, for whatever reason, have those slowed?
Yes, sir. Just to clarify, the SharePoint system started in July of 2010, as I indicated. At that point, it was a 3-day notification system. We have moved subsequently to a 1-day notification system. Right. But since July, we have had a handful of times, including one that I caught last month, that involved perhaps international equities that were inconsistently redacted. So I looked at it. I said, oh, wait a second. This needs to be reviewed and checked for consistency. So I did a reply all to the list and said this needs to be checked. I instructed my director to have it reprocessed, and it's in the process of doing it. But it's only been a handful of times, by my recollection, since the SharePoint system has started. But each time they have been indeed good catches and have caught information that otherwise would have been inappropriate to disclose.
Right. So your testimony is that none of those times that it was caught and slowed down, was it for a political reason, or was a, hey, we need to get our story straight before this goes out kind of issue? Absolutely not. Okay. The issue you brought up several times about catching up, which is great to be able to catch up on it. Obviously, a lot of people want to request a lot of information, and so it's great to be able to start getting caught up on some of the backlog that has been there. The document that I had received talking about a report from DHS and just the annual Freedom of Information reports to the Attorney General of the United States makes a comment about the length of time that it takes in 2009 versus 2010. Are you familiar with that report and some of the timing on it?
I believe I issued that report. I'm not familiar with that exact quote, but I am familiar with the report.
Well, let me just run a couple things past you. It talks about the median number of days to grant a FOIA information request of 45 days in 2009. It is now up to 93 in 2010. And in 2009, the average number of days
was 74 days. In 2010, it was 120 days. And so it's processing through whether the SharePoint system eventually is coming online. You see a lot of the backlog that's occurring there in the early parts of 2010, and now it's catching up and getting better. But you had mentioned we're getting a lot faster on it, but based on this report, it looks like it's slowing down somewhat.
So if I could clarify a few things.
Sure.
First, with regard to the awareness review, it was a very small number of requests themselves that were impacted, so they should have no impact at all on the processing. The number of days that you quoted is not that is not consistent with my recollection of the report, and so perhaps there was some numbers that I'm not familiar with. I'm sorry.
We'll get a chance to pull this and be able to share that with you, so you
absolutely,
can have it as well.
absolutely.
We'll just be able to get a response back. Once you take a look at it, if you have an opportunity to be able to get us a written response and say, here's what the actual numbers are, that would be terrific.
I would be happy to clarify that. Yes,
clarity on that one. What is the decision on making what is called a significant request? Heard about that a couple of times. What's the criteria that you set saying this one's significant?
The criteria for significant reporting, as I said, has essentially stayed the same since 2006, and it is to essentially be issues that will be discussed in the media so that we know that they are going on. As has been discussed several times, we receive an extraordinary amount of FOIAs each year. But there are only a handful of those that we would want to know that, oh, this has been filed, incidentally, this is going on. That weekly report is sent to the front office, but it's also sent to all of the FOIA officers so that they too can see that, oh, by the way, this component got the same request as another component. So it's for awareness purposes on essentially sensitive topics, priorities, and litigation.
If a private citizen made that and then handed it over to the media, that may or may not rise up. Some of it is the requester itself, or some of just the topic?
It's the topic. It's the topic that would be of interest. But of course, if the media has requested it, then we assume that it's a topic of media interest.
Correct.
So the media is a default usually to be included just for notification purposes that this request has been made.
Great. Thank you very much.
Gentleman's time has expired, and at this point we'll recognize Mr. Welch for 5 minutes. You arrived at the correct time, my friend.
Thank you. You know, this question of transparency is an important one, but my understanding is that you get overwhelmed with requests, and your position is that you are transparent and you're doing your job as best you can. Is that right?
That is correct, sir. I try.
All right. Just elaborate. I want to give you an opportunity to explain why you believe you're meeting that standard, which is one we share, and what you have been doing, and what your specific response is to some of the assertions that have been made about your failure to do that.
Thank you, sir. As we've discussed previously, the Department and the FOIA professionals therein have made Herculean efforts to get the FOIA backlog down from its high of 98,000 to 74,000 when I started to 11,000 FOIA backlog. They are under amazing pressure, and they do amazing work all the time. In addition to reducing the backlog, in addition to providing these services.
I'm going to interrupt you for a minute.
Yes, sir.
Because actually, here's what would be helpful, I think, for us and for you.
Yes.
Is to explain, all right, the backlog was X and now it's X minus. The number of requests was X and now it's 2X, and you've reduced it by whatever. But specific,
sir,
the more specific you can be, the better. Because I think all of us really respect and appreciate the hard work that you and your fellow workers are doing. So the more concrete you can be with us, I think the more helpful it is for the whole committee to be able to come to the right conclusion here. Absolutely,
sir. So we've, as I indicated, in FY 2009, we had a FOIA backlog of 74,000 FOIA requests. That has been reduced to 84% in the past 2 years to an 11,383 FOIA backlog request. In addition, we have received 102,000 FOIA requests last year while processing, this is FY 2009, while processing 160,000 FOIA requests. That work is primarily the work of the U.S. Citizenship and Immigration Services in addressing and being more efficient and more transparent and getting their alien files processing out. The U.S. Citizenship and Immigration Services accounts for 70% of FOIAs that are processed in the Department. They alone receive between 8,000 and 10,000 FOIA requests each month and have been able, through commitment by the USCIS, to be able to reduce that.
All right. Let me ask you this.
Sir.
There's some allegations in the majority's report, New Era of Openness, that the front office at DHS was interfering with FOIA requests by correcting errors with outgoing FOIA responses. Obviously, a somewhat troublesome assertion. And I want to give you an opportunity to tell the committee exactly what type of specific errors did the front office review help to correct.
So as I've described previously and as detailed in my testimony, the front office reviewed both the cover letter as well as the underlying FOIA response. They did not make any changes to the FOIA responses, but they did identify several times where there were typographical errors and other elements that were not consistent with professionalism standards that I would like, and they have caught those in their overall awareness review of the documents.
Okay. And then, according to the Inspector General's report on page 12, the IG provided that in response to allegations by the AP of a, quote, political filter being applied to FOIA responses at DHS, the IG stated, we were not able to substantiate the most serious allegations made by the AP story or subsequent public comments. However, we determined the review process led to inefficiencies in slower processing of certain FOIA responses. Based on that finding, what were some of the inefficiencies that you observed, and what steps were taken by DHS management, including your front office, General Counsel's office, and your office, to reduce any of these inefficiencies, and has the response time improved?
Absolutely, sir. We take these issues quite seriously. We had identified these problems ourselves and have self-corrected it. The initial original awareness process was done via email, and it was a relatively cumbersome process. As soon as we had a technology solution where we could provide an intranet-based system where everyone could access, we've moved from the email system to the intranet-based system, and that process has been much more efficient, and I believe is actually right now a leader in the Federal Government.
Okay, thank you. I yield back.
Thank you, sir.
The gentleman from North Carolina, Mr. McHenry.
Thank you. I wanted to point out to my colleague, Mr. Tierney, he questioned the posters behind the Chair's dais, and he says, question why there are political statements on the back wall. If the gentleman actually read the briefing document, he would know that that political statement is actually the title of the hearing. I just wanted to point that out so folks who obviously are in the audience have looked at the title of the hearing and see it on the wall, and that is not a coincidence, although some of my colleagues may think it is. With that, I'd be happy to yield the balance of my time to Mr. Gowdy.
I thank the gentleman from North Carolina. Ms. Callahan, what's the purpose of FOIA?
The purpose of FOIA is, of course, to inform the public of the workings of the Federal Government. And
what are the elements that you would apply in determining whether or not something were discoverable or not?
Discoverable is not quite the right term.
Well, you know what I mean, whether or not it should be produced.
I used to be a lawyer, so...
Me too, but whether or not it should be produced.
Well, as Mr. Fong has indicated, this administration applies a presumption of disclosure, unlike the previous administration. With that said,
I was not asking for a political comment. I'm simply asking for the elements that you apply to determine whether, not which administration is better than another, the legal elements that you apply in determining whether or not you should turn something over.
FOIA applies to all Federal records, and we seek to find all responsive Federal records. And we look at those Federal records, presume that the Federal record should be disclosed, but look in case that there are specific exemptions. There are 9 discrete exemptions that may need to be applied to documents or elements of the document.
So it should be turned over unless there is an exemption?
Yes, sir.
Okay. Then why would the employment of the person seeking the record matter?
It doesn't matter at all.
Why would that have been part of the calculus that was used?
Sir, it was not part of the calculus that was used. The weekly report that summarizes anything that may be of media interest may note who the person is.
How do we know it wasn't part of the calculus that was used?
I believe the Inspector General's report actually indicates that political calculations were not part of the process.
I'm not even getting to political calculations yet. I'm just asking about residency and employment. Why does it matter whether or not someone's a private person or whether they're a reporter?
It does not matter at all in terms of processing the FOIA request. Yes.
So why would you track that information?
It is only summarized because it may become part of media interest or attention.
Why? Why keep whether or not it's a private citizen that's requesting the information or a reporter?
So it's actually a requirement to disclose who's requested. It's a requirement in our law, in the Freedom of Information Act, to disclose FOIA logs, to actually say the name of the person who's requesting it, unless it's a Privacy Act request. And so that is disclosed.
And the employment of the person is required as well?
That is not disclosed usually, but sometimes the media affiliation may be part of the FOIA log. And we have our FOIA logs posted on our website.
What about the political affiliation of the person requesting it? Why is that part of the calculus?
It is not part of the calculus at all, sir.
You don't track whether it's a Republican or a Democrat that requests the information?
As I indicated earlier, there was under the FOIA, we've only gotten one FOIA request from a member of Congress during my tenure.
Would the gentleman yield?
Yes, sir.
You said, though, that when Senator Grassley, when his had gone through the whole process, it was ripe, it was delivered to the political review system in the office of the Secretary, that you took care of his request through other fashion.
No, I'm sorry, if that's what you had interpreted.
No, that's what you said. You said that, in fact, you took care of Senator Grassley's request through another system, but of course you didn't know about it until you were informed that a Republican senator had a FOIA request that was ready to go out.
No, sir, it wasn't ready to go out. It was the initial incoming. So the weekly report summarizes the incoming requests that come in. So they're just summarizing what the request is. So Senator Grassley may or may not have been on the weekly report, but as I said, we never processed his response pursuant to FOIA. We addressed it through other means.
I apologize. I'll yield back.
That's okay. I'm sorry if I had been.
I'll yield back. It's clear that you take care of politicians differently in the one case, but go ahead.
So this statement, if a member of Congress sought documents, employees were told to specify Democrat or Republican, that is an inaccurate comment.
According to our weekly report elements, we are supposed to indicate which is the Democrat, but as I said, which is a Republican, which is Democrat, but it hasn't happened.
Why?
I think that that's the way that you guys are usually addressed. I don't know why it was a recommendation by my career staff to add that into the standards from 2006. So the standards from 2006 were modified slightly based off of career FOIA recommendations.
Mr. McHenry, Mr. Chairman, therefore my time has expired.
I thank the gentleman. We now recognize the distinguished gentleman from Illinois, Mr. Davis. Oh, okay, I apologize. We'll next go to the gentleman, the distinguished but junior gentleman from Virginia, Mr. Connolly.
Thank you, Mr. Chairman. And since I celebrated a birthday yesterday, I particularly appreciate the junior. And thank you both for being here today. I'm not quite sure, frankly, why we're here today, because, correct me if I'm wrong, either Mr. Fong or Ms. Callahan, but I thought the Inspector General's report found that actually there was a lot more transparency at DHS in this administration than in the previous administration. Is that true?
I believe that is indeed one of the conclusions by the Inspector General. One of the things that my office established in August of 2009 is a policy of proactive disclosure to attempt to put up the frequently requested documents, to put up elements that may be people may want to seek. For example, FOIA logs. I know that the Chairman sought FOIA logs for several departments. We've put our FOIA logs up for the entire department for 2009, 2010, and now we've just updated 2011.
And thank you. And which, by the way, and at least speaking for this member, I continue to find the signs behind the Chairman and Ranking Member offensive and propagandist. And one of these signs is framed, of course, in the most biased way. It's not an intellectually honest question. It is, why doesn't DHS deliver on the President's transparency promises? And in fact, what you just said, your testimony, Ms. Callahan, and the report of the Inspector General suggests the answer to that question. He did. Would that the previous administration had been so transparent, and would that this committee, especially some on the other side of the aisle, had been equally as concerned about transparency and backlog and politicization at DHS under the Bush administration. Now, backlog. What was the backlog? How high did it reach? And was it true that the backlog of FOIA requests under the previous administration hit 98,000 at one point?
That is correct. That's the.
And by the time that administration left office, it was down to 74,000.
That is correct.
What is it now?
11,000.
11,000. So it's 1/9 of its height under the previous administration. Is that correct?
Yes, sir.
The idea of politicization showing horrors that somebody's political affiliation from Congress, when did that practice begin?
Sir, it was a recommendation from my career FOIA staff to add it, but I don't think it's material because, as I indicated, we don't usually receive FOIA requests from members of Congress.
That's correct. And in terms of notifying political leadership, if that's what you can call it, namely the non-career political appointees, the leadership picked by the President, often confirmed by the Senate, notifying them just of the status of FOIA requests, again, horrors. When did that practice begin?
In terms of notifying that responses went out, that actually has been a longstanding process. In
other words, it began in the previous administration?
The awareness review and having a systematic process actually started in this administration, sir.
This administration?
It did start in this administration, and I believe we have now a state-of-the-art solution to it.
You know, I was the chairman of Fairfax County, one of the largest counties in the United States before I came here. And Virginia actually has one of the most open sunshine laws and vigorous FOIA laws, at least at the local level of government in the United States.
Yes, sir.
Emails, phone logs, any correspondence, all memos are subject to FOIA, and very strict timelines in terms of getting FOIA requests fulfilled by the media or others. Now, I was the chairman of the county, and it was absolutely routine practice that our legal counsel's office would notify the political leadership of pending requests so that we weren't caught surprised. I find it shocking that some of my colleagues apparently think that's an untoward development. I think, personally, that's responsible management, just to make sure that they're aware of it. Is there any evidence, though, and maybe this is the nature of their concern, of political interference once made aware in responding to FOIA requests?
No, sir. I have no knowledge of any political interference with regard to the awareness review, and I believe the Inspector General made the same conclusion in his report.
Thank you. Mr. Fong, are you aware of any such political interference?
I agree that the Inspector General's report, which took a close look at this issue, did not find any evidence of improper political interference.
Would it be fair in your assessment, Mr. Fong, looking at the backlog progress and looking at the policies regarding transparency and the lack of political interference, one could conclude that, as a matter of fact, the transparency of DHS in this administration has significantly improved over the previous?
I think that's a fair statement.
Thank you. So we've answered that question behind the Chairman's head. I would yield back.
Thank you, Mr. Chairman. Ms. Callahan, if I can summarize this, there is a presumption in favor of disclosure. There are exemptions which you may avail yourself to. You do not believe there's been any political interference. Would you concede that slow walking or taking your time in complying with an otherwise legitimate FOIA request could be interference?
There are many steps to FOIA processing that could create delay.
Including slow walking something, taking your time and reviewing it and deciding when to disclose it.
I hope that wouldn't have happened, but that could be one of the many possibilities of delay for FOIA.
And that would constitute, you would concede, interference.
Our FOIA professionals take their responsibilities quite seriously.
That was not my question. My question is even simpler than that.
Yes, sir.
Is slow walking or delaying the disclosure of information interference?
It is delay, yes.
What about an overuse of exemptions in the redaction process?
That is also something that would give me pause. The Inspector General's report raises an issue that I had not previously identified, which is that the Department has been using the exemption B5, perhaps more. It has been using it increasingly throughout the past several years, starting in 2006.
Perhaps. You used the word perhaps.
But it has been increasing since 2006.
Where in B5 do you find an exclusion or exemption for the phrase, "this is bananas"?
Sir, I'm happy to defer to my legal colleague, but B5 is for pre-decisional and deliberative material.
Can you see any way where a B5 exemption would apply to an email that said, "this is bananas"?
I think we'd have to look at the context, sir.
Well,
would the gentleman suspend?
Yes, sir.
We provided documents to you, and
these right here.
Yeah, I would ask that the gentlelady be given an opportunity to review the document you're asking, and then we'll restart. Thank you.
Yes, sir.
Do you know where in the package it is? I'm sorry.
Would one of the slide 3, I'm told.
Slide 3. Okay, I have exhibits attached. Hang on. I don't have slides here, sir. I'm sorry. Maybe somebody
Yeah,
else
if you take care of making sure they have them.
Congressman, if the question is about the FOIA production, this looks like this is the FOIA production to the Associated Press. As I've indicated to the Chairman, my office did not process this request under typical process, typical standards. We were recused from the processing, and the Office of the General Counsel made the determinations in this specific FOIA.
Well, I can still ask you, right? I mean, you're still an expert in FOIA. Can you possibly find a B5 exemption for the phrase, "this is bananas"?
Part of the purpose of B5 is to have a vigorous and dialogue debate, and a reasonable dialogue. And perhaps it was the determination of the Office of the General Counsel that that was part of the deliberative process rather than a final decision. But as I said, I wasn't involved in this redaction.
What about, nope, they entirely changed our response, spoke with Jordan, and he is going to confer with OGC. Would that be a B5 exemption?
Sir, that also is part of the FOIA request from the Associated Press. I was not part of the process, but I do know the underlying facts in this circumstance. The Office of the Secretary had initially made some recommendations to modify our boilerplate FOIA responses to make them more streamlined, and they did not understand that, indeed, several of the paragraphs were required by law. And therefore, after consulting with the Office of the General Counsel, we decided to use the same standards. So therefore, that was indeed a pre-decisional document because we did not make the changes that were recommended by the Office of the Secretary. So in that case, again, I did not make the determination, but I think a B5 exemption would be appropriate.
You do think a B5 exemption would be appropriate for the phrase, "they entirely changed our response, spoke with Jordan, and he is going to confer with OGC"?
In this factual circumstance, that's because the response indeed was not changed.
Well, for those that may not be familiar, what is the process if you are redacting in an impermissible way? Who gets to review that? I mean, how do we know what we don't know? If you're redacting something, who gets to decide whether or not the redaction was appropriate or not?
As in my written testimony, I detailed the entire FOIA process, including the possibility of consulting with counsel. And then once the requester receives the response, they have several alternative appeal options, an administrative appeal, and also going to court.
I can't see edits. Are they useful? Now, why would that be a B5 exemption?
I'm sorry, sir. I am concerned about the overuse of B5 in this department. Mr. Fong and I have discussed it, and we're going to look at a systemic solution to the issues that the Inspector General raised with regard to B5.
We know it was coming. They are trying to substantially edit our letters. Why is that a B-5 exemption?
Sir, again, I do not have knowledge of the FOIA processing for this element, so I'm sorry, I won't be able to continue to answer these questions.
Would you agree with me that that's an appropriate use of the B-5 exemption?
Again, sir, this was not my processing.
The gentleman's time has expired. Now we go to the distinguished gentleman from Illinois for 5 minutes.
Thank you very much, Mr. Chairman. And, you know, since I sit next to the other gentleman from Illinois, I just wasn't certain. But since both Ms. Callahan and Mr. Fong have testified that neither are aware of any political interference in responding to FOIA requests, I'm going to yield the balance of my time to the ranking member, Mr. Cummings.
I want you to, thank you very much. I thank the gentleman for yielding. Ms. Callahan, I want you to, you know, first of all, I think you admit, and the IG will agree, that the system, things are not perfect. By the way, none of our officers are perfect. We've got great people, but they're not perfect. And I am concerned about this, you know, as the IG was concerned. He said his recommendation number 5, it says to recommend the Secretary that the Secretary issue written guidance to the Department on the President's reiteration, embarrassment, abstract fears, and the exposure of failure are not grounds to exempt information under FOIA. And you just said that you and Mr. Fong were working on addressing the issue of exemption number 5. Tell me what you are planning to do. I mean, what do you see? You expressed concerns. You said you're trying to do some things. How do you address that? Because one of my colleagues on the other side said, "How do we go forward?"
Yes.
Now, and I got to tell you, when you said that you all had reduced by 90%, the backlog, 80 whatever, 80%. Let me tell you something. That's phenomenal. Now, but we want to do even better. This President has said he wants to do better, and I want you to address that issue.
Sir, I want to do better as well. And one way with regard to this identification of B-5 using in the Department, as I said, I had not identified this as a systemic problem until the Inspector General brought it to my attention. Mr. Fong and I have not had a chance to do a thorough plan, but I think it obviously is going to look at the specific elements of B-5, how it's being applied, and also obviously training and materials and education will help to make sure that when exemption B-5 is being used, it's being used appropriately, and it should not be used for embarrassment purposes and so on. So I completely concur with that.
Now, how long have you been in your position, Ms. Callahan?
2 years, sir.
Were you in the department before then?
No, sir. I was in the private sector.
Well, let me ask you this. You referred back to 2006. You referred back to 2006 2 or 3 times.
Yes, sir.
And I was just looking at some guidelines, FOIA section of DHS Cabinet report to the White House.
Yes, sir.
Dated August 4th, 2006. And it talks about, it says, select FOIA request for submission if one of the following criteria is met. It says, one is the FOIA request is for congressional correspondence. The FOIA request is from a member of Congress. The FOIA request is from a member of the media. So that's been a policy since 2006? Without
change, yes, sir.
And when you came in and you're trying to do this more transparency, have an effort to make things more transparent, I take it that you go back and you review these kinds of things so you know what the guidelines are?
I did, sir, and I relied heavily on my career FOIA professionals with this regard. We looked at the 2006 guidance, decided to issue it as a memorandum from me to show its importance, but also added some ministerial and formatting elements to it to be, quite frankly, more professional and consistent with how we refer to things. But the substance of the submission guidelines have not changed since 2006.
So, in other words, there was nothing in between 2006 and when you came in?
Yes, sir. That's correct.
So that's what you had to go back to?
Yes, sir.
So is it safe to say that during the latter, I guess the Bush years, President Bush's years, 2006 through 2008, that these were the guidelines. Is that right?
That is correct, sir, and they remain essentially the guidelines today.
I see. Now, Mr. Fong, the IG made some complaints about your department, such as the department's commitment to producing documents is in question, DHS assertions about resources dedicated to complying with document productions. Our suspect made a number of allegations, and since you are not going to be here to answer those, but you are familiar with them, I think it would benefit the entire committee for us to know what your response is to those, because they were rather serious.
So, to clarify, you may have inadvertently referred to the Inspector General.
I meant the Inspector General. I apologize.
You meant the...
I'd ask a gentleman to have an additional 1 minute. Go ahead, please.
Yeah. Talking about the Republican staff report. I'm sorry.
Yes, thank you
I apologize.
for giving me an opportunity to respond. I have not had an opportunity to read the entire report in depth, but I did carefully review the allegations made concerning attorneys in my office, including career attorneys who have worked there with great success for some time. I confess that when I first saw the section headings, my initial reaction was one of concern, because, as you indicate, they make very serious allegations about lawyers I know well, and I take very seriously, as I should, any allegation of wrongdoing by my staff. Upon further examination of the portion of the report dealing with the OGC lawyers, however, my concern, frankly, turned into indignation, because I believe the report paints an unfair and, if I may say, an irresponsible portrait of certain people and events. The report reads more like an advocacy piece rather than a sober, substantive, dispassionate, investigative report. In that sense, the portion of the report that focuses on the Office of the General Counsel is quite unlike the Inspector General's report, which resulted from a serious fact-finding effort and makes 6 constructive recommendations, all of which the Department has concurred with.
Thank you. We've gone 2 minutes past. I think he's fully answered his opinion. We now go to the gentleman from Michigan, Mr. Walberg, for 5 minutes.
Thank you, Mr. Chairman. Ms. Callahan, in your written testimony, and I hope I'm not going back over a question that I missed while I was out at another committee for a brief period of time, but in your written testimony, you state that 2 years ago, the Department faced a backlog of more than 74,000 FOIA requests. Under this administration, you go on to state, we reduced the backlog by 84%, or more than 63,000 requests. In his interview with the committee, William Husserland, a member of your staff, pointed out that about 30,000 records were transferred to the Department of State. According to Mr. Hauserland, and I quote, literally boxes on pallets were dumped on the State Department when we had done our portion of the processing. I mean, do you feel that it's fair to take credit for backlog reductions that have simply been transferred to another agency and the records remain in the Federal Government?
If I could clarify exactly what that process is, I am familiar with the incident. As I had testified earlier, the U.S. Citizenship and Immigration Services has done an amazing job of processing their files. They receive between 8,000 and 10,000 FOIA requests a month for primarily immigration files and alien files. Under FOIA, each department processes their own records. So once USCIS had finished processing the DHS documents or the USCIS documents, they then go through a process that is typical in the Federal Government of referral. So because the USCIS was so successful in getting their backlog down in FY 2009, and for that I commend them, unfortunately, the Department of State was the beneficiary of that, because in some of those records, there were not only DHS documents, but also Department of State documents. We are attempting to, that is, I think, a one-time circumstance because of CIS's success in getting the backlog down. One way we could mitigate this is for CIS to sign a memorandum of understanding with the Department of State to process the Department of State documents, and I believe that's in discussion.
But again, this backlog wasn't reduced by your department, by your office.
No, and it's been reduced throughout the department by all the FOIA professionals, the 420 FOIA professionals that work hard every day.
Well, that may be the case, but the credit seems to be at a different spot. In addition, according to a recent AP report, a significant portion of the reductions achieved across DHS was a result of a Federal contract signed under the previous administration, the Bush administration. In light of the fact that a private company completed this work under contracts signed during the previous administration, is it not somewhat disingenuous for you to credit these reductions to this administration?
The reductions are the reductions, and as I indicated, the USCIS has made an incredible effort, and they have done so in coordination with contracts. That's certainly the case, and I applaud them for applying such a significant priority to getting that backlog down. They have done an amazing effort.
Well, credit where credit is due.
Yes, sir.
And politics where politics is due. Let me ask another question here. During their interviews, your FOIA officers stated that the front office approval was needed before they could release FOIA responses. Your Deputy Chief FOIA officer testified, and I quote, "They, front office, were, well, reviewing and then approving, yeah, absolutely, because if we couldn't send something out the door until they gave the thumbs up, that's approval." Do you disagree that that approval policy was in fact in place?
The original part of the awareness process was indeed an affirmative acknowledgment of that they have received the FOIA and that they have reviewed the FOIA. That had management challenges. I have admitted that, and I believe that we attempted to mitigate that immediately. We have now moved to a system which is a notification system, and I believe it is much more efficient.
Thank you. I yield. Would the gentleman yield?
I yield.
So just to review.
Yes, sir.
You took credit for a big reduction that's $7.6 million worth of Bush-era money, paid for a contract, and reduced it. You took credit for 30,000 records that were transferred to another workload of other people. Now, you have some really hard-working people, and I appreciate that. But how do those people feel about the day after our whistleblower and others giving testimony, the whistleblower gets taken out of her office, moved to an inferior title, and has her job narrowed in scope, and then, quite frankly, I'm told she's now on basically health leave. I'm listening to all of this, and I'm saying, isn't that the most chilling effect anyone could ever have, to see that if you tell the truth to Congress, the next day your job's reduced and your office is changed, and it's not called a demotion, but it sure as hell looks like one?
Sir, there are several elements of the process that I cannot speak to here, but happy to have a non-public briefing about certain personnel issues. With that,
my time has expired. We don't do non-public issues when a whistleblower is penalized and hundreds of hardworking people see the effect of testifying honestly under oath before Congress.
Sir,
time has expired. I yield back. Does the ranking member request a second round? Okay, we'll have a second round, and I'll begin. Mr. Fong, basically, Ms. Callahan has said she was recused in the process, but you were not recused. Your department were not recused. You're a political appointee. Many of the people in your department are political appointees, and the General Counsel's office regularly does redacting, including 5B. Isn't that true?
I'm not familiar with the specifics of the process. I believe
no. First of all, I'll make it simpler. You're a political appointee, right?
Correct.
Other people in your department are political appointees?
A few.
Okay. Your department does redacting. That's already been testified to, right?
The department does.
The General Counsel's office.
We may adjudicate or interpret the statute to.
You add things which get black lines over them. Isn't that true?
We provide legal advice to determinations made by the Office of Privacy.
Okay. So in the case of the AP's fairly sensitive request, constitutional, First Amendment, in addition to FOIA, they in fact found you doing the redaction of the material delivered. Your office, headed by a political appointee, did the actual redactions that are being talked about here today. Isn't that true? Your office, people under your control. Yes or no is all we need to know.
No.
Okay. Who did the redactions that we're talking about here today that Ms. Callahan is saying she was recused from, but we're seeing some pretty absurd redactions here? Who did them?
I do not know who made the specific redactions. I do know that a senior career lawyer was involved in giving legal advice to those who made the redactions. I can't speak to the specifics.
Okay. Well, I'm going to ask a kind of a closing question on this subject. The President said, and was unambiguous on his first day in office, that he wanted to err on the side of disclosure. If you had a recused department on a particular request, the AP request, why wouldn't it have been appropriate to meet the spirit of the President's own words to simply say to the FOIA career professionals, we're not going to second-guess this one. We'll err on the side of openness. You do what you think is right, and you deliver it, and we won't have it further reviewed by those in your office and others that might have suggested further redactions, some of which look like simply covering up embarrassments or, if you will, deliberative cover-up conversations. The meaning of these items, which we are releasing today, it's a very small part of the discovery, have never been given to the Associated Press. They've been denied the Associated Press for 9 months. Why is it wouldn't have been appropriate in either one of your answers, yes or no, to have erred on the side, as the President said, and had the career professionals do it, and take your chances that maybe just once something would get out that wouldn't be perfect, even though it was done by the career professionals?
Mr. Chairman, it would not have been appropriate because the President's memorandum did not say to ignore the law. The law includes exemptions. We are duty-bound
okay.
to interpret the law.
I've heard enough of a political appointee, political appointees, who interfered clearly with career professionals. We have a whistleblower who your organization has punished that was part of an overall disclosure that we've become aware of. Let me just close because my time, too, is limited. We're not done with this. The minority may think that this is not right. Our expectation is from this day forward, we want the rest of the documents that were requested. We want to see them all. Additionally, I'm putting you on notice that as we view the AP request, which is 9 months delayed, they have not had their day in court to get some of the things that we're seeing here today. We're going to have additional hearings so that we fully understand line item by line item each redaction that they're waiting to see 9 months later and haven't seen. So I would ask, quite frankly, that you do what you need to do to ensure that we don't have another hearing. Make an expeditious decision on this appeal. You know, 9 months for the Associated Press to want to know about something that, in your own words, have led to changes, material changes in how you do business in the FOIA section. And 9 months later, the AP is still waiting on responses to these. And the only answer we got here today is, well, I didn't review them, I was recused. I didn't actually work on it, but we can't actually explain why It's Bananas, in fact, gets redacted. That's something the American people, they expect every day that the press asks and the press gets answered. And the FOIA statute is unambiguous that, in fact, it's only through narrow exemptions. And if those exemptions have been abused once, and it's deliberate, then they've been abused. With that, I yield to the ranking member.
Thank you very much. Mr. Fong, as a lawyer, and I used to represent lawyers when they got in trouble, and I know that license to practice law is very, very important. And we are held to a very high standard as officers of the court. And when I asked you about the allegations in this report, I could tell that you got a little bit emotional, and probably you share what I share. I know the feeling. I want to give you a chance to respond to some of these allegations, because there's something that, while the Chairman and rightfully so, is concerned about people being demoted. I'm concerned about that too, but I'm also concerned about people's reputations. And lawyers, we have a high standard to set. You started talking about the lawyers in your office. There have been allegations that have been made that could possibly lead down the road to some serious problems for those lawyers. So I want you to respond. And by the way, most of the lawyers, I would guess, could be making a lot more money if they were in private practice or doing something other than government work. But they're dedicated employees, and I refuse to allow them to just be a blanket of negative allegations to be placed upon them without at least giving you a chance to respond.
Thank you very much, Congressman, for giving me this opportunity to supplement my answer to your earlier question. It is, as you indicate, truly unfortunate that the attorneys who are the subject of the majority report are in fact career attorneys, a line attorney in one instance and a senior attorney for the Department, to have their names dragged into a public report simply for performing their duties as attorneys for the United States Department of Homeland Security. I've reviewed their performance in representing the agency in this investigation and continue to do so. I have not found any indication of unethical activity or improper practice of law. The DHS attorneys I know are hardworking, dedicated professionals. The report has some salacious headlines, but this report simply does not describe the attorneys I know and work with. I also want to underscore that I believe we have fully cooperated and acted in good faith with respect to this investigation. I thank you for this opportunity to respond.
And Ms. Callahan, I'd like to give you the opportunity to finish what you were saying. Again, the Chairman talks about fairness, talks about people's reputations, talks about demotions, but there have been some serious allegations made here, and I don't know what the truth is, to be honest with you, but I'd like for you to at least be able to answer the question.
Yes, thank you very much, sir. Catherine Papoy remains in the same position that she's held in this office, Director, Disclosure and FOIA, and in fact, she competed for a promotion, a new SES position that I was given by the Department, demonstrating the importance of FOIA by this Department. The competition was open. It was a laborious and detailed process involving several different career SES panels. Ms. Papoy was not selected, and that was confirmed by the Office of Personnel Management.
And when was that decision made?
The initial selection of the proposed new SES was December 17th, 2010.
All right.
Ms. Papoy was informed that she had not received the promotion on January 10th of 2011, and then we were working on onboarding the new SES. That process takes a while. It goes through security. The new SES cleared security on February 24th, but was not released from her department until officially March 2nd. On March 2nd, we received notification that her department had released her. That's required in order to have her move on. And we were informed by the Office of the Chief Human Capital Officer that indeed her first start date would be March 14th. We then took the first opportunity. We attempted to notify Ms. Papoy on March 4th, which would have been the day after her testimony, but it was in order to give her notice that this was happening. She certainly was aware that the new SES was coming on board. She did not know the date certain. So we were attempting to tell her with as much time as possible so that she could move offices. The office moves are comparable offices. I had made a decision to have the new SES closer to me because now the new SES is one of two people that reports to me directly.
Very well. Thank you.
I thank the gentleman. We'll take a 5-minute recess to set up for the second panel.
Thank you.
Oh, I'm sorry. Mr. Walberg, did you want a second round? I apologize. We recognize the gentleman.
Well, I did, and I appreciate the opportunity.
And you do.
And I get it, right? Moving from Ms. Papoy, I want to go to Exhibit 7, if we could have that shown. In this email to Amy Schlossman, the Deputy Chief of Staff, you explain why the FOIA office must repeat the requester's language verbatim to minimize legal liability. Amy Schlossman responds by saying or writing, legally we have to repeat allegations in FOIAs. Can we get a read on that prior to tomorrow, the meeting tomorrow? What does Schlossman mean, can we get a read?
I'm not sure. I believe she's addressing two people. I wasn't copied on this portion of the email.
But you responded to it.
No, sir. I believe I was the original email, and then she forwarded on to two colleagues asking for their response to
well, what do you think she might mean by, can we get a read?
I believe she was asking whether or not my summarization was fulsome and complete.
You're the Chief Privacy Officer and a lawyer.
I am not a lawyer in this position. I just need to clarify that.
Well, I'm a minister, and I'm always a minister. You're a lawyer, you're always a lawyer. We can't get away from it, can we?
That may be true. That may be true, sir.
Why did she have to go to the Office of General Counsel?
As with any office, there certainly are reasonable disagreements on different positions, and she was just confirming indeed that what I had said, she was probably making sure that that was indeed accurate, and I believe she received that confirmation.
Do you believe the front office staff had an appropriate understanding of, or appreciation of FOIA statute and processes?
I believe they have a much more robust understanding of FOIA than when they first arrived.
So that's changing?
I hope so.
I yield my time.
Would the gentleman yield?
Yes, I would.
Because I believe the next panel is going to be very different, I'd like to summarize a couple of things about this hearing that I think have come to light. One is, this hearing has never been about the reduction in the backlog of FOIA, whether that was produced by contractors paid over $7 million, by new equipment, or by transferring to other departments. This has been about somewhere north of 1,000 requests that were politically sensitive, that involved the press in most cases, many cases, in one case a member of Congress. Those are the only ones we've ever really talked about. If they don't get special handling, as we're well aware, the Office of General Counsel often has no impact on thousands and thousands of requests. The career professionals receive them, make decisions, and send them out. Those are the ones that this committee, in our oversight role, are pleased with. We're pleased with the vast majority of them. We're pleased with the thousands of FOIA professionals throughout the Federal Government. So I just want to make clear at closing, this is not about the reduction or the increase, and as a matter of fact, it is not about the very, very great and positive words that President Obama said on day one when he wanted to make a statement that there would be more openness and that if effectively, in my words, you err on the side of disclosure, that in fact we don't want to err on the side of secrecy, particularly at Homeland Security. This would be important. So as we go into the second panel, we meet with the IG and others, hopefully we will all understand that we want to limit this to only the portion which is by definition controversial. The forwarding, and SharePoint is a great piece of software. I'm very familiar with it. It's a good investment. But forwarding it so that somebody can make a decision which we can only know in their own minds, their deliberative process, has to be scrutinized by this committee because we are the committee of all of the questions of abuse, and we're the overseer of the Hatch Act and other laws designed to keep politics out of the policy of the executive branch. I thank the gentleman for yielding. We'll now take a 5-minute recess to reset.